Cardinal Turkson, Your Honors and colleagues, it's a great honor to be invited to this brilliant conversation. My topic is cultural colonialism in the administration of justice. In your invitation, it's noted that colonialism suppressed indigenous forms of justice and still does so today. One difference is that neocolonialism or neocolonialist suppression is more difficult to define and identify than domination by conquest or command. My talk concerns one of the most difficult contexts of all, the suppression of indigenous justice in the name of universal justice. Universal justice is binding and coercively enforceable, but cultures differ in what they think justice demands. So what looks to the United Nations as the enforcement of a human right may look like imperialist duress to those on the receiving end. I want to consider how one might reason about this question in one such case, the enforcement of adversarial criminal justice on cultures that have different traditions. Before addressing that in the context of the International Criminal Court, let me say something about the larger human rights issue, of which the one I will talk about is just one instance. To me, the adoption of the Universal Declaration of Human Rights in 1948 was a great moral advance. But human rights are also deeply rooted in Western history, and some see them as an updated version of the civilizing mission, undermining traditional cultures in the name of superior values. Even the human rights scholar Michael Ignatieff describes human rights doctrine as, quote, now so powerful, but also so unthinkingly imperialist in its claim to universality that it has exposed itself to serious intellectual attack. One of these attacks comes from Mikao Matua, who calls universal human rights a universalized version of the Western liberal tradition. Quote, a testament to the conceptual, cultural, economic, military, and philosophical domination of the European West over non-European peoples and traditions. Matua analogizes their influence to 19th century missionaries who he claims devastated African societies by displacing indigenous religions that underpinned almost every aspect of life. I am unqualified to evaluate Matua's empirical claims, but his analogy is apt in the way Christian missions then and human rights now are potentially destabilizing to traditional cultures. Both exalt autonomous choice, individual conscience, and moral equality in a world where many societies remain hierarchical, communal, and role-based. So the fear is that grafting individualist and egalitarian values onto such a society is likely to undermine the supposed natural order on which it and the identities of its people are built. One crucial difference between then and now is that we feel a much stronger obligation to respect indigenous cultural traditions today. In 1835, the British colonial administrator T.B. Macaulay could say that, quote, a single shelf of a good European library was worth the whole native literature of India and Arabia, unquote. That is a world away from Pope Francis's words of apology to Canadian Indigenous peoples for the, quote, lack of respect shown for your identity, your culture, and even your spiritual values, unquote. It is precisely the opposite of the pluralist essence of the human rights idea, which prescribes respect for self-determination and diverse ways of life, but also conformity to certain universal moral constraints. That is the theory. In practice, that line is quite difficult to draw. What does respect mean applied to a society that confines women to the home, absent a male guardian, or maintains other oppressive traditions foundational to their way of life? When John Rawls, a philosopher known for the rigor of his arguments, tried to specify the limits of international tolerance, in his book, The Law of Peoples, he had to resort to what he deemed common intuition, unquote, and explicitly left it to readers to judge according to their own intuition. His intuition was that tolerance must extend to states that enforce a gender or religious hierarchy, and he narrowed the set of human rights accordingly. So is there anything more to guide us than bare intuition? For the International Criminal Court, this question is unusually pressing. Understanding what separates international justice from neo-colonial injustice is basic to its role, and reasoning is central to its opinions. Now, there's no doubt, of course, that the substantive crimes within the court's jurisdiction are universally unjust: crimes against humanity, war crimes, genocide, and aggression. But what justice means in their wake is highly contested, and it is here that neo-colonial concerns come to the fore. That is especially true when a state objects to the court's jurisdiction on the ground it is handling the case itself. This is a jurisdictional restriction under the ICC's complementarity rule, which defines the ICC as a court of last resort, solely a backstop to prevent impunity when a state falters. Suppose a state wants a non-criminal restorative justice process rooted in its own traditions to count as a bar to ICC jurisdiction. The court must then decide whether that approach is sufficient and publish its reasons. Would its insistence on criminal prosecution and punishment instead constitute a Eurocentric abuse of power? I want to consider in very abbreviated form how it might reason its way to an answer. A restorative justice response to crime aims at acknowledgement, forgiveness, reparation, reconciliation, and the reintegration of offenders, not criminal punishment. The most celebrated example of its use following mass criminality remains the South African Truth and Reconciliation Commission. The TRC granted amnesties to applicants who provided a full account of their crimes. It was empowered to provide reparations. It was rooted in tradition and was a prerequisite to the abdication of the criminal apartheid regime. There are many who would say that that was an inadequate response, precisely what the ICC was founded to avoid. But numerous states have resorted to truth commissions and amnesties either to end brutal conflicts or to address crimes following them. There is widespread agreement that general amnesties to all perpetrators of grave human rights crimes violate international law. But the provision of conditional amnesties to individuals who testify truthfully as part of a reconciliation process presents a different situation. Neither the Rome Statute, which established the ICC, nor its case law definitively states yet whether such a process may constitute a jurisdictional bar. This leaves the ICC to grapple with some fundamental moral questions. First, does justice in the aftermath of crimes against humanity always demand prosecution? Second, if it does, should justice give way if continued tyranny or bloodshed would be the likely result? And third, whatever its own answers, how much should the court defer to contrary views of a state or its people? Now, it's possible that there is no way to bridge the cultural divide between adversarial criminal justice, which is the ICC model, and a traditionalist non-criminal alternative. But taking cultural imperialism seriously requires the court to interrogate its own adversarial criminal model with respect for other traditions and see if common ground exists which might serve the ultimate values behind each view. The specifics of both traditions may be contingent means to a broader and deeper universal end, or it may not. In the time remaining, I will consider the reasons supporting strict reliance on criminal justice to see if it's the only way to achieve the ends these reasons suggest. And I take these reasons in very summary form to be three: a retributive reason that perpetrators of such crimes must receive their just deserts; a social contract reason that states owe victims prosecution of their victimizers; and consequentialist reasons of various sorts, such as that failing to prosecute and punish such crimes makes their recurrence more likely and reconciliation less so. So I'll take those three, and the only point of this is actually to use the ICC as an example of, is there a way to reason your way to a line between neo-colonial injustice and universal justice? So first, justice. Start with the retributive ground for prosecution that the perpetrator must receive his just deserts. Of those who believe this, some take that to require criminal conviction and punishment and imprisonment, others do not. Utilitarians view that course as irrational. Restorative justice devotees think it is unduly focused on the perpetrator and the past. Some faiths and cultures think it is unenlightened. In any case, the court could reasonably view prosecution and punishment as a contingent means to a more widely shared and broader moral end of accountability for one's crimes. And on that score, both criminal punishment and the TRC model satisfy the standard of accountability in different imperfect ways. Criminal punishment holds perpetrators accountable by confinement and servitude, but only those it can find and convict. The South African process held perpetrators accountable by exposure, disgrace, and at times introspective guilt. And because it had the amnesty incentive, it imposed this kind of accountability on many, many more than would have been obtained by criminal punishment. It also appeared better able to expose culpable corporations, media, and other institutional actors who may have been one step removed from a pattern of atrocities, but more responsible for them. The other justice that I believe is owed is to the victims, and that is, I think, truly universal. Every state has the obligation, because its legitimacy depends on representing all of its people. If it does nothing, it denies the victim's civil status as a member of the polity. But is criminal prosecution and punishing perpetrators a necessary part of this obligation? In my country, the United States, we act as if it is. If it is, though, it is far from the only kind. In South Africa, conditional amnesties meant many more victims learned what happened to them, why it happened, who was responsible. That they had been victimized was incontestable after perpetrators publicly admitted their crimes, often in televised hearings, as opposed to conflicting stories that criminal trials may generate. And also, unlike criminal trials, victims were at the center of the TRC proceedings and could question their victimizers. So let me move to the second reason for prosecution and punishment, which is the impact. The Rome Statute's preamble conceives the ICC's role as twofold: ending impunity and contributing to the prevention of grave crimes. The hope is that prosecuting crimes of this gravity and scale will prevent their recurrence through its deterrence and norm-reinforcing effects. I'll note that just recently we've seen a possible example with the arrest warrant issued against Vladimir Putin, but time will tell. A complicating issue is that there may be devastating consequences from pursuing prosecution as well. That prospect may induce a criminal regime to cling to power or insurgents to refuse to lay down arms, and it commonly does. In that case, the consequentialist hope must be that consistently investigating and prosecuting war criminals will produce enough good in the long term to justify the more immediate horrors it produces. These dilemmas raise what is commonly labeled the peace versus justice problem. It engages the ancient question, should justice be done though the heavens fall? The Rome Treaty purports to answer yes. It makes many escape mechanisms available, however, in the event. I can't address that issue that has occupied consequentialists, deontologists for millennia, but I will note that truth commissions could provide a third option. In the right circumstances, they may allow peace, while at least avoiding the injustice of state and international indifference to victims of criminal atrocities. And the third issue I think that the ICC has to take into account in order to address the issue of cultural imperialism is pluralism. How much deference does the ICC owe to state approaches that differ from its own system, adversarial system? In one way, very little, because all state parties to the Rome Treaty have consented to be bound by the court and its procedures, and I think that's why Professor Hagan thought it did not generally raise colonialist questions. But the fact that they have signed the Rome Treaty does not obviate the court's task of defining the scope and limits of diversity in state approaches to accountability, nor its obligation to serve all peoples impartially. Given its pluralist commitment, when reasonable moral disagreement exists, as it does with the issues here, the court should tread lightly in enforcing one contested view over others. It should also give weight to self-determination of peoples and cultural survival. That most of the victims in the ICC's very first referral involving the Lord's Resistance Army and Uganda, that most of the victims favored the reconciliation process the Acholis use of Mapu Opet, is not dispositive, but I think it would have to have weight. Collectively, these considerations suggest to me that a well-constituted non-criminal truth commission should be an acceptable alternative in the right circumstances. They also have the broader implication that the ICC would do well to facilitate the devolution of real justice to state and local jurisdictions. Two particular steps could advance this devolutionary goal. First, I said that truth commissions may ameliorate the peace versus justice conundrum, but this is only true if they deliver real justice. The court has not done this yet, but it could help assure that this happens by enunciating a set of standards and best practices for truth commissions against which the acceptability of a particular state institution will be assessed. And second, the court could enhance what has been called positive complementarity, which is assistance that strengthens a state's capacity to provide justice through its own institutions. The court has jurisdiction when a country is unwilling or unable to do justice, and those in the latter category should receive aid and technical support from the court or from the international community to build or rebuild its judicial infrastructure and capabilities. Assistance of this sort would also help address a much more public charge of neocolonialism that has been leveled against the ICC, which I have not addressed here. For many years now, African leaders have claimed the court harbors an anti-African bias in its selection of cases. An overlapping objection is to the Security Council's ultimate authority over cases, which imports the unequal power of its members into the court. 3 of the 5 permanent members of the Security Council have refused to join the court, but they may vote to refer other states to it and veto referrals of themselves and their allies. The more states are empowered to do justice themselves, the less the court will be subjected to complaints about ethnocentric bias. And I will just close by noting that the controversy over the judicial so-called overhaul in Israel, the ICC is playing a role through positive complementarity because the military, much of the military has opposed this judicial overhaul on grounds that it would be considered not a sufficient response and leave them subject to the ICC jurisdiction. Thanks.